Yes, we're recording.
Thank you, Rosalind. Okay, that's it.
Sorry about that. Okay, so I'll try again. It's a well-known fact that many medicines are excessively priced. And the Pharmaceutical Accountability Foundation was actually founded with the goal of providing a structure that can tackle high prices of medicines through legal procedures. So long term, we aim to establish through case law and through legislation that the pharmaceutical industry has a binding duty of care, and that charging an excessive price for a medicine or other medical technologies should be seen as a tort in law. So in the end, PAF aims to make pharmaceutical companies charge fair prices for their products so that they're affordable for both health systems and for patients, and at the same time to provide sufficient incentives for innovation and the production of medicines. Slide, please. So many NGOs are engaged in the fight for more equitable global access to medicines. I've put a few ones on the screen. Of course, there are many, many more. They're a hugely important part of this endeavor, starting with HIV, when there was civil society played a massive role, and NGOs were really critical for promoting prevention and treatment. We've also seen a massive civil society movement coalesce with the outbreak of COVID-19. And many of these NGOs were already advocating for access to medicines, and others created special campaigns to promote access to COVID-19 products. This was really important given the unequal distribution of vaccines and therapeutics that's occurred so far. NGOs use a variety of methods to hold pharmaceutical companies accountable for the prices that they charge and to fight barriers to access. These methods may include strategies such as naming and shaming, awareness raising. It could be direct engagement with the companies to make them more aware of human rights and to encourage them to improve their practices. It could be campaigning for better laws and lobbying the relevant institutions, be they health institutions or political institutions. Next slide, please. Yeah, so however, it's not always clear which legal actions these organizations have to promote access to medicines. So this is why PAF has designed the legal guidelines for NGOs to promote knowledge of the different legal procedures that may be used in this field in one guiding document. The guidelines draw on examples from past cases, and they analyze the lessons that can be learned from them and the ideas that they can be applied to future issues. So in this webinar, we have a fantastic panel comprised of experts in the legal, advocacy, and public health fields. That Sabina will introduce them to you in just a moment. They'll discuss cases in which they have personally been involved and which they've personally found legal procedures to be successful or not successful in promoting access to medicines. So this event is really about the panelists' stories. We hope you enjoy them. I think it's going to be really, really interesting, and we'll have time for discussion later on. So over to you, Sabina.
Thank you very much. Yes, we will get to our panel indeed, and we will hear interesting experiences with legal procedures from our panelists. They have about 7 minutes each, and after all their stories, there will be some time for questions for clarification. And after that, there will be a discussion where we can learn from the presented cases for current COVID-19 pharma practices. But first, I want to introduce the panelists to you. I'll start with Mark Haywood. He is a human rights and social justice activist since the 1980s. He's based in Johannesburg, South Africa, and he was one of the founders of the Treatment Action Campaign and would rather be a poet than an activist. Nevertheless, he will talk today about how around 2000 South African NGOs organized access to ARVs by making use of competition law. The second panelist is also a member of our advisory board. That's Ms. Ellen het Hoen. She has been spearheading international projects on access to medicines for more than 30 years, with Médecins Sans Frontières and as the first director of the Medicines Patent Pool, to name a few. This year, she was awarded a Dutch Royal Award in recognition of her work on access to medicines. And she will tell us about making use of compulsory licensing. Sergei Golovin is a specialist in monitoring availability and prices of essential medicines and is now lead on intellectual property and access at the Treatment Preparedness Coalition in Eastern Europe and Central Asia. He will tell us more about government use for remdesivir. And Felipe de Carvalho is journalist and advocacy coordinator for MSF in Brazil. Also, he coordinates ABIA, the Brazilian Interdisciplinary Association on AIDS. He will talk about how the Brazilian constitution has been used to get access to ARVs and about a recent Supreme Court decision which invalidated 3,500 COVID-19 medication patents. Mrs. Nele Meijer is legal advisor on business and human rights for Amnesty International. And she will tell us about due diligence on the basis of human rights and how companies should adhere to it. So we will hear from each panelist. You have 7 minutes each. And when all stories have been told, there will be 10 minutes for clarifying questions. Audience, if you have a question, please write it in the chat. And can we start with Mark, please? Mark, are you there? Can you maybe, are you on mute still? I can't hear you or see you. Ooh, you froze.
Let's go on to
Okay, then maybe we can start with Ellen. Is that possible? And then we'll do Mark later. Happy to. Good. Please, Ellen, you have the floor.
Good morning, good afternoon, good evening, wherever you are. I have a few slides. Can I share my screen? I cannot share my screen. You have to give me permission. Could you do that? Almost there. Can you see my screen? Okay, terrific. All right, I have the near impossible task to talk to you about the use of the TRIPS flexibilities in 7 minutes. I hope I'll succeed. This is my interest declaration. It basically explains why I am still poor, no interest to declare. In 95, as you probably all know, the World Trade Organization was established, and with that, the TRIPS agreement, that is the agreement that regulates intellectual property globally, was adopted and became the binding international norm. Key of the TRIPS agreement was the obligation to grant 20-year patents, and that it became no longer possible to exclude entire fields of technology. Before TRIPS, countries would, for example, exclude pharmaceuticals or food from patentability. That was no longer possible as of '92, with some exceptions for countries that could benefit from transition periods. Civil society organization and NGOs, because that is the subject of this meeting, were not involved in the negotiations of the General Agreement on Tariff and Trade that led to the establishment of the World Trade Organization. And thus, the TRIPS agreement, I think it is fair to say that if they had been involved and if the TRIPS agreement had been negotiated during or after the emergence of the HIV pandemic, for example, we would never have had the TRIPS agreement. But that is a subject for a different presentation. Now, after the adoption of the TRIPS agreement, you saw a dramatic increase in patenting of HIV medicines. And I show you this because this is important to know, to be able to understand what happened fairly shortly after the TRIPS agreement was adopted, because that took place more or less around the same time that the AIDS pandemic had taken off, but also fairly soon after that, effective antiretroviral medicines had become available, but in high-income countries only. They were priced out of reach for most people on the planet who were living or rather dying with HIV and AIDS. Now, talking about legal procedures, NGOs are perhaps not as experienced with using legal procedures to get what they want, but the pharmaceutical industry certainly is. And what also happened shortly after the adoption of the TRIPS agreement in 1998, and Mark Haywood knows all about this, he was there, the 39 companies sued the Nelson Mandela government over a rather trivial amendment to the Medicines Act that would have made it a little easier to import lower priced medicines that related to parallel importation. I won't go into the details of that. But in fact, ironically, this legal case helped spur a global movement for access to medicines, because it laid bare internationally the very grave, inequitable situation and the mad situation where companies were even trying to squeeze more out of countries and out of populations that were already in a desperate situation. The issue had been taken by the African countries to the World Trade Organization's ministerial conference, which took place in Seattle. Well, I should say did not take place in Seattle, because this is what Seattle looked like. I was there at the time with Médecins Sans Frontières. Luckily, we were there with sort of war experienced logisticians, and we were one of the few NGOs that could actually move around in the city. So we had a chance to talk to many of the country delegates who were sitting doing nothing in their hotel rooms, to convey the message that something had to change, that the rules had to change in order to allow access to lower priced antiretroviral medicines. These discussions continued after Seattle, once the dust had settled, and culminated in 2001 in the adoption of the Doha Declaration of TRIPS and Public Health. And this is a declaration, page and a half long. I always advise everyone to just spend a few minutes reading it, because it is a very clear declaration, and it draws attention to the flexibilities that exist in the TRIPS agreement, but it also creates new rights, in particular for least developed countries who were no longer obliged to implement the provisions for pharmaceutical patenting and data protection. And that is an important exception for least developed countries that continues until this day. Now, focus in the 3 minutes I've got left on two key TRIPS flexibilities. I should stress TRIPS has more flexibilities than these, but these are flexibilities that have been used in the direct procurement of low-cost medicines. One is compulsory licensing, that or government use, that refers to a measure, a government or a government authority taking the decision to make use of a patent without the consent, without the agreement of the patent holder. And with that measure, you can, for example, import generic versions of the medicines or produce them yourself. The second is the LDC transition, which means least developed countries do not have to grant or enforce existing pharmaceutical patents. Today, this is still the case until 2030. And these flexibilities have been used on a fairly large scale, initially predominantly for importation or access, in some cases, local production of HIV medicines, mostly antiretroviral antiretroviral medicines, but in later years, you see the uptake of these flexibilities for non-communicable diseases. And of course, in the recent 2 years, we've seen some countries use them in the context of COVID-19, but we'll hear from someone else about that in a minute. Now,
So
the
you're
use
in
of
your last minute, Ellen.
yeah, I know, I'm doing my best.
You're doing well.
The use of the TRIPS flexibilities, and I can't go into what NGOs and civil society have done to make this happen, but that has been quite important, not only in formulating and highlighting the norm at the international level, but then subsequently at the national level, lobby for the governments to use them. We keep a database with those instances. There are 108 instances as of today of the use of compulsory licensing and government use by governments. This is for medicines only. Most of those have been executed, and it's interesting that the ones that have not been executed, about half of them, or a bit more than half of them, have led to other measures such as price reductions or a voluntary license or a donation. We also see on a large scale the use of the LDC extension. So where least developed countries say, with a reference to paragraph 7 of the Doha Declaration, I authorize this importation. So this has been incredibly important in real life access to medicines, mostly for HIV, but later, as I said, also for other medicines. And we've also seen a number of important compulsory licenses, for example, for antivirals for the treatment of hepatitis C. And this is my last slide. This is just a screenshot of the database, but I would encourage any of you who want to have more information to visit this database, because every entry has hyperlinks to much more data. And as to the overall history, which is much longer than you can cover in 7 minutes, all of our material is available for free open access on our website. I thank you.
Thank you so much, Ellen, for your very interesting talk. And I think this is a good start of the panel. Mark, I see you. Can we also hear you?
Good afternoon. Yes, I hope so.
Yes, we can.
Good afternoon. My apologies. I had a temporary loss of internet here in Johannesburg, but it's come back. Thank you for holding this timely and important discussion, but also for the opportunity for us as activists to interact with each other. It's timely because I feel as if at times we're living in the era of the absolute power of big pharma. And I think that it is necessary to talk about strategies to limit that power and to reassert medicines as public goods and as human rights. It's interesting to hear Ellen's presentation about the ways that the Doha Declaration and TRIPS flexibilities have been used, but it's also important to say that there are many countries like mine in South Africa, where through bilateral trade agreements and other means of pressure, even though we have it within our laws and within something like the Doha Declaration, we have actually not utilized these flexibilities to the detriment of life and to the detriment of public health. I was asked to speak about one particular example of how in South Africa, the Treatment Action Campaign used the power of law to challenge the abuse of patents. And I will do that. But before I get to that, I just need to make 2 important points of context, which I think built upon the important international presentation given by Ellen. The first point is that 25 years ago, almost exactly in South Africa introduced a new constitution for our country, which became the supreme law. It was a product of the end of apartheid. But I think what was important about, or one of the very important things about this constitution, was that it has a Bill of Rights, and within the Bill of Rights, it states that everyone has a right of access to healthcare services, and that the state must take reasonable legislative and other measures to ensure the progressive realization of that right. In other words, what it said is that the rule of law trumps corporate power when it comes to essential human rights, such as the right of access to healthcare services. And that is what I'm going to come to in a second. The second important development or significant development was that by the late 1990s, the HIV/AIDS epidemic in South Africa had escalated. By 2000, the year 2000, we were seeing up to 1,000 HIV-related, or 2002, 2003, HIV-related deaths a day. And this was all taking place in the context of important developments in science around antiretroviral medicines, which in developed countries had changed the face of the AIDS pandemic and had made it possible to live with HIV rather than die of AIDS. And those developments brought into sharp relief this question of the pricing of medicines, in particular the pricing of antiretroviral medicines, and what powers the state had to make those medicines more affordable and therefore more available to people. And this was the basis on which in 1998, we human rights activists formed the Treatment Action Campaign in South Africa. I think many people will know about the Treatment Action Campaign. It was a campaign set up really to challenge big pharma's power, to challenge the price of medicines. It became about many other things as time went on. But from the very beginning, I want to say, because this is a discussion about the power of law, that whilst law is a very important instrument, it really should be seen as one instrument that is used effectively with other strategies. Rarely does law work on its own in the interests of poor people and people who need to protect their right to health. So from the beginning, for example, the Treatment Action Campaign publicly imported, illegally imported generic medicines, a drug called fluconazole, in defiance of the law, in defiance of patent law, and challenged the pharmaceutical companies to come and arrest us. We were involved in demonstration and shaming of the bosses of pharmaceutical companies, almost challenging them to sue us for defamation by putting pictures of some of the bosses and calling them AIDS murderers and so on and so on. And we defended the state's right to regulate the market in the public interest. This is the critical point, which is that the pharmaceutical market is not sacrosanct. It has to bow to the interests of human rights, and in our country has to bow to constitutional law. And I want to finish with 2 points before I come to the particular case that have to be made, which is, although we always wanted to win in a court of law, we used the courts to win in the court of public opinion as well. That is a critical thing. And the second thing is to say that law is not just about the ultimate judgment in your favor that you seek, but it is about the process of law that allows you to put science on the table, that allows you to put evidence on the table, that allows you to draw attention to inequities and inequalities, and therefore makes an issue like medicine patents a moral question as much as you make it a legal question. So I want to say that because I don't want any 2 minutes, I know, to think that power, that law very often works on its own. So having said
1 minute,
that,
sorry, Bob.
I'll very
only 1
briefly
minute.
refer to the case that we brought in 2002 using the law at our competition commission, where we brought a case regarding excessive pricing of 3 antiretroviral medicines against GlaxoSmithKline and Boehringer Ingelheim. We situated that complaint on the basis that the companies were abusing their monopolies to set prices that had no bearing on the actual R&D costs of those drugs, and that by doing so, that they were violating the Constitution. We brought it on behalf of individuals with HIV, on behalf of several doctors and of several organizations at the same time. In South Africa, I'm speeding now, but in South Africa, competition law involves a 2-stage process. First of all, an investigation. If an investigation finds prima facie evidence of an abuse of patents, abuse of competition law, it's referred to a tribunal. This case was referred to a tribunal, which was a success for us. And at the point at which it was referred to a tribunal, the pharmaceutical companies came to us to want to negotiate a settlement. Now, I'll finish by making this point, which was that we were criticized in 2003 for entering into a settlement with the pharmaceutical companies, which meant that we didn't get a binding legal judgment on this case. But we were motivated at that point by the need to save as many lives as possible. And what the settlement allowed was the issuing of voluntary licenses, 7 voluntary licenses on these 3 medicines, which basically broke the monopoly on these drugs. And by breaking the monopoly on these drugs, made it for the first time affordable for governments to include these drugs in national treatment plans, not just in South Africa, but all over Africa. It made it possible to develop a generic pharmaceutical industry in South Africa, which began to mass produce these medicines. And ultimately, I have to say that this one case and the campaign around it has probably contributed to saving more than 5 million lives in South Africa from people with AIDS. So I've had to give you a very truncated version of this, this case. I want to just finish by saying that it shows you that Big Pharma is vulnerable, but it depends on how you use the law to take these companies on. And I'll stop there. Thank you very much.
Oh, thank you so much, Mark. And I really apologize because 7 minutes is just too short for all these interesting stories, but we'll have to do with it. And you still have a discussion with Wilbert, so you might still bring stuff up. Okay. So the next speaker is Sergey. Please, Sergey, you have the floor. And Mark, can you mute?
Yeah.
Thank you very much. Could you maybe share the presentation for me so that I...
Yeah, I'll do that.
Yeah, and while I'm waiting for the presentation, oh, it's already there. Thanks, that was quick. Thanks again for inviting me, and thank you, Mark and Ellen, for such tremendous presentations. I think it's something we've been learning from over those years. So I would like to give you a short briefing on the government use license for remdesivir in Russia. It's the first ever government use license in Russia, well, and I would say probably in the region of Eastern Europe and Central Asia. Next slide, please. When speaking about this license, I think it's important to underline that there was a really long process behind it. And this picture you see on the screen is actually a photo taken in 2006 with HIV activists protesting on the Red Square about patents, and they actually wanted everyone to have access to life-saving meds. And even at that time, they started to realize that it was impossible without utilizing TRIPS flexibilities, without utilizing such tools as compulsory licenses, and without using generics. And well, you can imagine from 2006 till 2021, it took, well, 15 years to actually issue the first ever government use license. And this license was not for the HIV drug or hepatitis C drug, but it was for a COVID-19 experimental drug. But still, there were two cases when we came really close, and it was 2015, when there were huge debates about issuing a CL for HIV drugs in Russia. And 2016 and 17, when we nearly got to the compulsory license for sofosbuvir, a hepatitis C drug. And we've not yet surrendered our attempts to have access to generics, because Russia has no access to generic DAAs for treating hepatitis C as of now. But those were like really huge campaigns involving a lot of effort from the civil society, which actually paved the way to the decision, which I'm going to talk about in a little while. Next slide, please. And of course, it took some research and persuasion. And here you see a very extensive document published by TPC-RU, the organization I work with, about the use of compulsory licensing, which has very detailed information about the legal background, including the TRIPS flexibilities that Ellen was referring to in her presentation. A really extensive overview of existing practice, some debunking myths about the CLs, which are very common across the world, and recommendations for better use. That was a very interesting document. We're really proud of it, and it's just one of the examples of the attempts made. Next slide, please. So coming to the decision itself, again, 15 years, and now we see the first ever government use license. It's a very specific document, and just for you to see, and it provides all the necessary information: who, how, what patents, the duration, the purpose, and the legal background. So it's, in itself, it's a pretty short document. We have it translated into English, the decision itself, so I can share it with the participants of this webinar if needed. And it was good to see that, well, it wasn't much to argue about. It was very precise, it was very transparent, etc. Next slide, please. And as for the legal background, it's really important to underline that at the same time, there was a huge campaign which started in 2015 aimed at improving and amending the government use license law in Russia. And the purpose of it was to add healthcare to the list of grounds for issuing government use licenses. Importantly, this decision was made under the old version of the law, but now in 2021 we finally, after maybe 6-7 years of campaigning, have a law which explicitly mentions government use licenses for healthcare purposes. And there were a number of other laws which came into force. So there was like a package of compulsory use laws adopted in 2020, 2021, which is really, again, important. And on the slide, you see some brief information about those. Next slide, please. So some facts, some timeline benchmarks. I won't go into too much detail. Some really important things that I have to say, that this was a very fast process, and yet we didn't get in time, because while the decision was being discussed, there was disappointing data from WHO regarding the efficacy of remdesivir. So we started discussing this license when remdesivir was like a more promising drug than it's now. But still the government decided to issue the license. And another important point is that the companies seeking the license, Pharma, they were very open about it. They came to the media, they explained the use of TRIPS flexibilities, they explained it was not violation of the law, blah, 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 blah. So the publicity around it was really important. Next slide, please. And there were counter attempts from Gilead. They actually tried to sue the Russian government for issuing the CL, and they used some grounds for it. They lost, not surprisingly, but that was a very dangerous precedent, and it really explains why the TRIPS waiver we are all, well, not all, but many of us are fighting for now, is really important, because in each particular decision, to use TRIPS flexibilities, the pharma companies will push back. And although they lost, but still it was like a dangerous precedent. And another important thing I want to underline, that the patent holder is still on the market trying to sell their drugs. So another example of how myths around CLs can be debunked, that it's actually like trying to take someone's property in the form of patents, which in fact it's not. And this would give us a great opportunity to actually analyze the investment climate after the CL. Yes, I'm finishing. Yes.
1 minute. Yes.
Yeah. Thanks. And to show that in fact such decisions have no impact whatsoever on the investment climate, and they have no impact whatsoever on the behavior of the patent holders. Next slide, please. And this is actually my last slide, and I want to emphasize that besides compulsory use licenses for COVID, this was the first ever government use license. We had licenses issued by court in Russia before that. Apart from this mechanism, there are other really important TRIPS flexibilities discussed at the moment, and I think it's really important to try to avoid adopting a patent linkage regime. It's something which is widely discussed in Russia and the Eurasian economic countries now, and sadly enough lobbied by EU-based companies and US-based companies. And I think it's important to unite globally and with a strong message that no TRIPS plus measures such as data exclusivity or EU. Yes, I know, Ellen, thanks a lot. This is what makes it really unethical, that it's actually recognized by the European Commission as an unethical practice. But still, EU-based companies lobby for adopting it in other countries, and it's really not good that they're doing it in the time of a pandemic. And it should be a strong message, I think, globally. And we need to continue developing, enabling a transparent environment for the further use of TRIPS flexibilities in other countries such as Armenia, Belarus, Kazakhstan, across the world, which would help them to get better access. So we see examples such as dolutegravir, where we could have had better access if we used CLs instead of other tools. So, and of course, supporting the TRIPS waiver. Thanks very much. I would like to conclude with that.
Wow, Sergey, thank you very much. It was very interesting talk, and not much long.
I did my best.
No, it was really good. Thank you. Felipe will be the next speaker, and he asked us to share his slides. I think they're already up there. Yes, so Felipe, please, you have the floor.
Thank you. Can you see my slides?
Yes, we can.
Okay, perfect. Thanks a lot for inviting me for this so interesting panel. So I would like to start by just a few words about Brazilian civil society work on access to HIV treatment. As in many other countries, Brazilian civil society has been a cornerstone of the response to the disease in the country. And one of the major contributions by local groups has been the early association between HIV/AIDS and human rights. So since the 80s, actually, Brazilian activists have been building this link, and this later on influenced even the government's own agenda on health diplomacy. So this means that the response to HIV/AIDS relies as much on human rights-based policies as on biomedical interventions. And that treatment is much more than just putting pills into bodies. It's about restoring people's citizenship and dignity. So this slide you see in the screen is from a very important Brazilian activist that was pretty much in favor of the concept of solidarity when we deal with health issues. And this was the concept that was the base for Brazil having a public health system that is inclusive and free of charge for everyone, free of discrimination. So this was very important for the inclusion of the right to health in the Constitution of Brazil, and for the creation of universal treatment programs in the 90s. And actually it's important to say that the treatment of HIV/AIDS in Brazil was beneficial not only for its own population, because we saw reductions of mortality of over 50%, but also for the rest of the world, because actually the fact that Brazil was producing generic drugs in large quantities promoted economies of scale around the world. So if you see in this graphic, that's actually from a book by Alan, the drugs with the white bars are drugs that were produced in Brazil as generics. So for those, the prices of the raw materials were much lower. So this way, Brazil helped even Indian companies actually to start to offer very cheap prices for their own products. And this had a very important effect in the global treatment of HIV/AIDS. So the question I would like to focus now is, so how law has been used by Brazilian civil society to enable and sustain these kind of social gains on access to HIV treatment, and how this has paved the way for actions with impact in other diseases, including COVID-19. So first of all, there were several individual judicial actions demanding access to drugs in Brazil. These actions were based on the right to health that was in the Constitution. And this were very important to make sure the program of universal treatment was created, and then that new drugs were incorporated from time to time. So in this graphic, we see the red bar is the delay between a drug was approved by the US FDA and the approval in Brazil. So we see the orange bars are the number of individual judicial actions requesting this particular drug. So when we had more individual actions, the time difference between the approval in the US and the approval in Brazil was much lower. So this was a way to show that these actions were contributing to really establish not only a good program, but a program that also incorporates new drugs all the time so people can have the best treatment. Brazil also engaged in the defiance campaigns that our colleague from South Africa mentioned. So in South Africa, for some of the first MSF treatment programs, there were drugs coming from Brazil in a defiance campaign that, as he said, we were actually willing to showcase how industry, multinational companies were trying to control treatment and block generic drugs. And at the same time, we are trying to show how developing countries could have their own response, produce their own drugs, and supply each other. So this was something that involved MSF, but also Brazilian civil society, South African civil society. So it was a very important and powerful case, but it was more like a defiance campaign. And lastly, we also saw in Brazil several law actions and litigation strategies around patented drugs, because they started to represent a huge burden for the budget of the Brazilian HIV/AIDS program. As you can see in this graphic, most of the budget was consumed by patented drugs starting in the year 2000. And this was a threat to the sustainability of the program. And at that moment, more than 100,000 people were relying on that to stay alive and well. So there were many actions on IP for sure, compulsory license campaigns, patent oppositions, but I would like to focus on the litigation strategy, because there were two major cases in Brazil in the Supreme Court. The first was challenging what we call the pipeline mechanism, which is a system that revalidated some patents in Brazil. And this had a huge impact in the budget because drugs that should not be patented were patented in Brazil. And there was, until 2019, a financial impact of $1 billion thanks to this provision. So there is a case filed by Brazilian civil society challenging this provision and is waiting for judgment since 2009, actually, but it's not happening. It was put in the agenda of the Supreme Court a few times, but then canceled. But it's a case in which we are still trying to get a final trial, a final ruling. But there was another case, and I will finish with that one, because in Brazil, we also have what we call the patent term extension mechanism. So if the examination of a given patent takes too long, there is additional monopoly term for the patent holder. So any extra examination time that goes beyond 10 years is compensated. And as a result, Brazil has one of the highest, actually the highest average of patent term duration in the world. And taking the patents that lasted for longer periods, the average is around 30 years in and in comparison to most of the countries, that is around 20, 23 maximum. Brazil is quite higher. So this was also something that was harming Brazil's capacity to supply drugs to its own population and to contribute to the global market dynamics, helping to reduce prices and helping other countries to get fair prices. So we were fighting against this provision since 2016, and finally this year actually the trial was considered by the court, thanks also to the environment around COVID, and the fact that when we look to the patents that are extended through this mechanism, there are some of them are related to drugs that are maybe helpful for COVID, not only for treating COVID, but also post-COVID conditions like anticoagulants and things, drugs that are important for COVID care. So this case was finally on Supreme Court agenda, and there was a strong battle between civil society organizations, generic industry in one side, and multinational companies in the other side. But the Supreme Court ministers, they voted with the majority of 9. We have 11 Supreme Court ministers, and 9 of them voted in favor of the thesis that we were defending, that patent term extensions are a violation of the right to health. So thanks to this decision, 3,400 patents have been revoked immediately, and other 2,600 patents will not have extension in the coming years. So this had already an effect for some of the COVID drugs, and we expect that this will be also very helpful for HIV drugs, TB drugs, diabetes, that are also in the scope of this decision. So yeah, I think that's my final point. And just to say that, yeah, using strategic litigation and having civil society voice in spaces like the Supreme Court is really important. It really made the difference in the decision that was reached around this case. Thank you.
Thank you so much. This sounds like a very important win, not only for people in Brazil, but also outside. So thank you very much, Felipe.
Thank you.
Then we'll come to our next speaker, which is Nele.
Yes, thank you. Thank you very much for having me. I'm a little bit nervous about the time limit as well, so I will try to bring lots of information in the few minutes. I would like to go back to actually what was said very much in the beginning. The companies have human rights responsibilities, and I would like to share with you a report, or the findings of a report that Amnesty published in September of this year. So as mentioned, I think by Mark previously, it's the states who have the obligation to ensure the access to medicines for patients, but companies do have a human rights responsibility as well, and that is firstly not to impede states in their obligation to ensure access, and secondly is to extend access to medication. So, and when we looked at this legal responsibility under human rights under the international human rights, we looked mainly at 2 factors. We didn't look so much at the pricing, but we looked at the challenges around production and allocation. Why did we so? Because we when we looked at this very skewed rollout of vaccination, where there were so high vaccination rates already in Europe and in other high-income countries compared to low-income countries, we identified mainly several obstacles to a fair rollout. But the two most important ones we found was actually an insufficient global production of vaccines, and with the stock that was available, that actually the allocation was not fair. So that there was, from the companies who produced vaccines, there was a tendency to ship those vaccines to the high-income countries. So, and when we look at those obstacles, we broke them down, and so that to overcome those obstacles, we saw a number of issues, and many have been mentioned here already. This was one, on the one hand, when it comes to the production issue, that the companies were not sharing their intellectual property, they were not participating in CTAP, which is the international instrument set up by the international community to actually share technology, intellectual property, and knowledge. Then when it comes to the allocation of the vaccines, which was very much within the realm of the decision power of the companies, we saw two issues. On the one hand, the fair pricing. So depending on, so as you all know, the price is an extreme challenge for certain countries to access medication. But then when it comes to the allocation, we saw that companies very differently distributed their vaccines. So we looked into 6 companies. That was AstraZeneca, Johnson & Johnson, Moderna, Pfizer and BioNTech, and then lastly Novavax. As you know, Novavax has not yet actually started to selling or to distributing its vaccines. So currently our work continues much more on the other 5 companies. And we found with their allocation of vaccines that actually they acted very differently. So in the time of September, when we published, AstraZeneca had distributed 66% of its doses to low-income countries and low-middle-income countries, while Johnson & Johnson had distributed 21% of its production to those countries, Moderna only 12%, and Pfizer not even 2%. Despite all of them actually publicly committing very much to fair access to the companies. So what did we do? So firstly, we obviously we did this research, but we engaged with companies and their investors actually to request them to reveal to us what kind of due diligence would they carry out with regard to human rights impacts, and what was their conclusion, and how they intended to overcome actually the human rights problems at issue. When I talk about due diligence, this is a reference to the UN guiding principles on business and human rights. This is an international standard which highlights the responsibilities of companies with regard to human rights. And so in principle, it underlines that there is a responsibility on companies to avoid harm, to avoid human rights harm through their operations or their business relationships. So obviously, so you can imagine, while engaging with the companies about the failure to comply with the human rights responsibilities, so we had engagement, we had a dialogue with them. There was much commitment on paper to those human rights principles, but so far we have not really seen much change. We challenged the companies. We set them a 100-day challenge because we published our report on the 22nd of September, which is 100 days before the end of the year. We challenged them and we said that actually to achieve the target set by the WHO to vaccinate 40% of the population by end of the year, that they should deliver half of their production by the end of the year to low-income countries and lower middle-income countries. That, as we had calculated, that this would be allow actually to achieve this target. While the companies have increasingly delivered to low-income countries and lower middle-income countries, they are still far away from this target. But this is an advocacy example, And what is very important is that we obviously see it is difficult to achieve our objective there. So that's why we also, parallel to this, engage very much on a middle and longer term strategy. We are engaging at the EU level on the due diligence legislation. So this is a legislation which is intending to embed the international human rights responsibilities of business into regional and local laws in order to be able actually to hold companies legally accountable at a later stage. There are already in 2 countries 2 such national legislations, Germany and France, which would be very interesting as regards BioNTech and its responsibilities. This legislation has been adopted in Germany. It will come into force in 2023, or it's into force, but it will come into effect for BioNTech or for the German companies in 2023. And this will, for instance, be an avenue where we really need to look into it, because on the ground of such legislation, you can, on the one hand, request as a government request from companies preventive measures, and later, so to a certain extent, actually for victims to ensure access to justice. So we are looking very much at this. Sorry?
Your time is up. I'm sorry.
Okay.
Can you
so
make your last sentence, please?
Yeah, my last sentence, it would be, so we are looking very much into this for future potential legal avenues, and I would be happy to discuss in more detail.
Thank you so much, and forgive us for hurrying you and all the other.
Oh no, for sure.
We had some time reserved for clarifying questions, but no clarifying questions came in via the chat. So looks like everybody understood everything, or is there one burning question that somebody wants to pose? But only one. 3-1? No, good. We won some time. That's great. Thank you very much. I will now hand over to Wilbert, because he will lead the discussion into the panel. I will shift the vision to Wilbert.
Good day all. So my name is Wilbert Bannenberg, and I must say I'm really impressed by all the presentations. I relived some of the memories. I was in South Africa in 2001, and I looked for myself on the picture mark, but I couldn't see. I was there also. So I'm the chair of the Pharmaceutical Accountability Foundation. I'm a doctor by training, but worked always in low and middle income countries on access to medicines. And now the problem has shifted. It's a global problem of access to medicines, how to get vaccines, and now to deal with these expensive medicines that are patented. So what we've heard from Alan, that we should reread Doha Declaration. We've heard it's very important that we actually use to the maximum the flexibilities that are there, and if they're not in your law, then you should make them in your national law. What we heard from Mark, of course, was that this was an enormous crisis. I remember that 1,000 deaths every day. And then, you're in a war zone, so you have to do something. Good that we could actually win the case by naming and shaming, and by bringing people who have HIV/AIDS as friends to the court, and that we actually could not actually win the case against GlaxoSmithKline and Boehringer is forgiven to them at the time. I think it is important that the principle was set that by Mark that rarely law works on its own, so you have to combine it with a good NGO movement. And this actually talks very well into what we are trying to do in Pharmaceutical Accountability Foundation, that we want to make guidelines for NGOs, how they can use the law and how they can actually take legal actions if necessary. And hopefully we will win also in a court of public opinion, like Mark said. Well, Sergei, I'm very proud of your country that you actually managed to get the first government use license in Russia being issued. Okay, it was remdesivir, not a very useful drug, but the principle of its happening, and then seeing that this was after you campaigned for HIV/AIDS, for sofosbuvir, and now for Corona, I think that's extremely important. And the campaign will go on. Actually, that you also make international exhaustion possible and fight for other things that are more like TRIPS minus rather than TRIPS plus in Russia. I learned from Felipe that, like in South Africa, you need a good constitution. From that, if the constitution is good, you can actually do a lot of things. But then, of course, you still need to be able to benefit from them, and you have to campaign and also use the courts. And it was good to hear that your case finally threw out 3,500 patents because of that patent term extension. That actually is good to hear. I also was very much intrigued by the statement of your famous activist, who I forgot his name, who said that there will be a cure for AIDS, but today its remedy is solidarity. And I think solidarity is not only the name of a WHO trial and trying to use medicines for corona vaccines, but that is what we need. And Dr. Tedros actually is really screaming, I think, more or less, diplomatically speaking, that we need actually to share knowledge, share the patents, share the skills, and actually increase the capacity of vaccines on this planet, because it's just not acceptable that we actually go on for years more in this pandemic. Nele, I think also I was very much intrigued by you, because I think you actually walk the same path a little bit as what we did with our good Corona company practices, basing yourself on human rights, and then actually going to say, what should companies then really do? And it's, of course, extremely difficult. They only adhere to the human rights when it fits them. They, of course, when it actually is going to cost them money or going to be a problem for them, then it will be actually, then they don't actually give in. And so there must be a way to actually make sure that the principles, which were translated into responsibilities by Paul Hunt, that we actually get them involved in national legislation, and that we actually get duty of care also for drug companies in order to make sure that they deliver medicines in the right way, in an equitable way on this planet. So I'm very happy to hear all this. The question, of course, is where do we go from here? What can we learn from, and I would like to also ask the panelists, I mean, each of you, what you would think is the way forward now, learning from the stories that we've heard about HIV, AIDS, hepatitis, now COVID, and so on. Who would like to take the floor from our panelists?
We have a question from Mark in the chat. Mark, maybe you want to say it out loud.
Sure. Let me just go back up quickly. So my question was just this, that the actions that have been presented this afternoon, successful actions, all take time, and they're often drug by drug. And yet there's a growing and urgent need for a range, and I would say an exploding range of life-saving medicines. In South Africa at the moment, we have a cancer crisis and very little affordability of crucial cancer medicines. So the question is, how can we address these issues holistically and systematically? Because taking it on a case-by-case basis is not fast enough to save lives? Thank you.
Well, that's a good question. Obviously, the Pharmaceutical Accountability Foundation also wants, in the end, a sustainable system where the law is actually on the side of the patients and the consumers, so that we can get medicines at a fair price and not at an excessive price. And if patients are not getting access, that there is a duty of care, and that we could probably improve this due diligence and get better get better legal binding, preferably things for pharma. As we have heard, as activists, we have not only to have the law on our side, we also have to have a movement, and we need to actually convince our governments and our parliaments. So I see already 3 hands. I think Ellen was first, and she's also the lady. So please, Ellen, will you?
Right, I won't comment on that, but I think Mark is spot on. And actually, I had, if I'd had more minutes, I would have ended with what we really need is, because in fact what we're doing with these things is what Michel Kazachkin once called palliative care. He even referred to the medicines patent pool as palliative care. And at the time I felt a little insulted. I just established the medicines patent pool, but of course he was right. I mean, we are continuously, if you look at the last 20 years of access to medicines campaigning, as successful as it has been in certain parts of the world in particular, it is tinkering with a system that is fundamentally needs to change. And that change needs to come, that change will not come from drug companies as such. There are people within drug companies that recognize that. You'll find them in particular in the research and development department, less so in the commercial side of the companies. But that change will have to come from policymakers, from governments, and it would have to be in the area of financing of the innovations, because that's where things have gone wrong. The predominant norm is that you finance medical innovation through granting monopolies. And if you grant monopolies, you get inaccessible pricing, and you get also a research and development agenda that is geared towards markets there where you can sell your products at the highest possible price, not necessarily where the most important health needs are. So as numerous UN reports and WHO studies and what have you have pointed out, we need to have a system of delinkage whereby you finance innovation directly and divorce it from the pricing of the products so that they can go to market at much lower cost. But that requires sort of government leadership and international collaboration, because it's difficult for individual countries to do that on their own. Over.
Ellen, very right. So, and apologies for my inappropriate behavior. I will now go from left to right. And then Felipe is the one who is first.
Thank you, Wilbert. Yeah, no, that's a very good question from Mark. And I think we all have, in a way, have a dilemma around that. So, of course, the case by case is also helpful in terms of creating precedents and jurisprudence. So it has a spillover effect in other areas, but in a way in Brazil we try to have this Supreme Court cases also as a way to skip the drug by drug approach. So in this case we were challenging the provisions through which thousands of patents have been granted. So and we have been lucky enough to win one of those cases. So that's something that has an impact on several diseases and several drugs. So that's one option. But also, I think the other point that we have been trying to raise in Brazil through legislative advocacy, it's to normalize some of the flexibility. So we have a more regular use of compulsory license, a more regular use of patent opposition. So more actors are using, and it's not treated as the exception of the exception. It's more like a regular need from the government to use those mechanisms. But I totally agree with Ellen that if we are be ahead of the curve, we should work on national R&D reforms and having in our own countries the linkage as a principle underlying the R&D systems and practices and policies. And lastly, my final comment, that's not something that MSF has as a position, but Latin American civil society groups have been more and more discussing a major reform that should come after the discussion of the waiver, which is maybe considering again removing essential drugs from patentability, from obligations around patentability. Of course, countries who decided to have it as mandatory can have it, but that developing countries have the option, as it was before TRIPS, to exclude some essential fields like drugs or food or I don't know any other essential goods from patentability, and this would maybe would look like more as a systemic solution for countries and would work for across disease areas as a solution.
Thank you, Felipe. I think the waiver discussion is already difficult for a year. I think to get some exclusions on patentability would be an even more difficult one. I'm not a lawyer, so I don't want to comment, but first I would like to hear from Sergei and then from Nele what their points were.
Yeah, thanks a lot. Essentially, I would probably repeat more or less what Ellen and Felipe have said, but maybe with slightly different words and slightly different accents. I mean, trying to answer your question, Mark, I think is what essentially two directions. And direction one is that we operate within the possibilities provided by the TRIPS and the Doha Declaration. And basically, I think we as a global movement, we need to strengthen this message for all the countries that basically it is okay to issue compulsory licenses. Every country has a sacred right to issue compulsory licenses no matter what. I think it's like it's common knowledge for us activists in the field of healthcare, but you know better than I do that as soon as we get to the level of countries, national levels, I mean, there is extreme, enormous lobbying from pharmaceutical companies. And trust me, in Russia, we saw so many like really blunt myths spread about total lies, said publicly in the largest newspapers, and without even a hint of like shame or anything. There's just complete lies. And it's like incredible. So from us, I mean, it has to be really strong pushback saying that, come on, like wave this Doha Declaration as a flag, saying like every country has a right to issue CLs, every country has a right to issue strict patentability guidelines, use international exhaustion. It's in the Doha, it's in our international. I mean, stop those lies. I mean, and it has to be a really strong campaign. So that's I think number one, and I agree totally with Felipe and Kellen. Case by case is still important. And it's a shame that in the time of the pandemic, when it's supposed to be like an urgent need, we still see like just one or two compulsory licenses. And still we are like 2 days to discuss the waiver. And direction two is TRIPS enough? And this one is a more tricky one. And the waiver and the challenging like the opportunities provided by TRIPS as a whole is a complete new story. And I think it requires a lot of discussions and debates, but thanks.
Thanks, Sergei. Yeah, Nele, please take the floor.
Yeah, thank you. There's not much to add to this, but Sergei just spoke about the sacred right of governments. It's actually, from our perspective, there is actually an obligation under human rights law, because if you want to protect human rights, you can already argue it's a failure to base access to human rights on a market-based system. So as Ellen actually mentioned before, so we argue that the system where innovation is based on investor engagement and market-driven systems, that this puts directly actually obstacles to the state's ability to ensure access to medication. What I would like to highlight is actually that from our side, it's not only a question of high prices. So the exclusive rights that are given by intellectual property in the context of a pandemic, where we are required to think about how to distribute a limited stock of essential medicines, actually companies need to make their distribution decisions on the basis of human rights. And that's clearly something that we don't see here. So when you look at Pfizer has a pricing policy where it actually says, as we will deliver at cost price to low income countries. But if the company decides to sell mainly to high income countries more than 90%, then the low price actually is only a promise on the paper. Thank you.
Exactly, it's a hollow promise, and I've been discussing this with Pfizer for many times. So, is there anyone else in among the 42 participants who is dying to say something? This, of course, is only a very few minutes. 4 minutes left. Mark, were you happy with the answers by the others?
Thank you. They were very helpful answers, and I think it shows that we need various strategies operating at the same time if we are going to tackle this. I mean, the only thing that I also added, Wilbert, is that I really think, and perhaps this is something your project is going to do, that we need to find better ways to communicate these victories across the world so that activists can learn from each other, but can also take heart from the fact that there are victories in different countries. Because as I said in my comments at the outset, sitting here in South Africa just now, it feels like these companies are far more powerful than they were when we were fighting them over access to AIDS drugs in 2000 and 2003. That's what it feels like in this part of the world.
I agree, Mark. I think Ellen still has her hand up for some very wise words.
I don't know whether they're wise words, but Mark, where I sit, I think we feel exactly the same. At the beginning of the pandemic, I think some of us, I certainly was, very naive, thinking this is going to be such a colossal health crisis. Things will be different. It won't be business as usual. There will be room and political willingness to create these vaccines as global public goods. Pharma will come on board. I honestly thought that, and I was very optimistic about the WHO establishing the COVID-19 technology access pool. I thought all these governments that are spending billions, hundreds of billions on the development of these products will work with that. And what did we see? It was business as usual. And now this business has become so large in terms of money value that it has become too big to ever become human again. So it's so that is the negative, sort of awakening moment. On the other hand, at my more optimistic moments, I think COVID will also offer opportunities to advocate for more radical change, because in fact, no one said when this pandemic hit, oh, well, we've got this fantastic incentive system. Let's just sit back and see what pharma will come up with. No, government stepped in and started to finance the innovations that are necessary. They didn't do the subsequent steps of making sure that those innovations then also became accessible, but it did shift things in the system, I would like to think, and that is perhaps a good ground or a good, some good experience that could offer grounds for discussions for further change.
Thank you, Ellen. I think we have to reply to these pharma companies that when you do business as usual, we do action as usual. So the experiences that you all have presented today and referred to, we are going to analyze them and put them into our NGO guidelines that are there for using the law and also for legal action if needed. So I think the time is nearly up, so I'll give the floor back to Sabina.
Yes. Thank you. Here I'm back again. Well, I hope you have become as inspired as I have from this panel discussion, because so much interesting material came over the table. So I think it will take a while to digest this. The outcomes of this webinar will be used to improve our paper on guidelines for legal actions by NGOs. That will be done by Rosalind Turkey, our researcher. And we will present the final version of this paper in our upcoming webinar. Yes, another one in December. A link to the YouTube version of this webinar will be posted to you and can also be found on our website. And while you are at our website, please consider if you want to support us explicitly and receive our newsletter. And this being said, I want to thank the panelists again for sharing their experiences and the audience for participating in our event. And I will say to you all,
Emily, thank Emily.
Thank you, Wilbert. And I thank Emily for helping us to run this webinar, and Rosalind, who did this from France. These are indeed our hidden powers. This will lead me to saying to you all again, good morning, good afternoon, good night. And with this, I end this webinar. Thank you.
Thank you, Sabina. Okay.
Bye. Thank you.
Thank you very much. Thank you very much and goodbye. Thank you. Great panel. Thanks a lot.
Thank you. Go well, everybody. Thank you.
Yeah.
Okay, Mark and Nele, thank you very much. And Ellen and Sergei and Felipe. Yeah, thank you, thank you, thank you.
Bye. Een soort Sinterklaasactie. Blijf maar zwaar.